Welcome back, viewers. If you're joining us on the PI show, we're with Martin Smith, a lawyer of 35 years' experience, discussing airline injuries.
Before the break, we were discussing what's called the Warsaw Convention, which is a no-fault benefit scheme. It has a few unusual features. One is it's got a 2-year statute of limitations, and it can't be extended, I don't think, under any circumstance.
No, look, I was going to touch on that, Harry. I mean, it's pretty significant because 2 years goes pretty quick.
So if you've got an injury, you've got to put in a claim or start proceedings within the 2 years. You've got 2 years and 1 day, you're out.
That's it. You've got to issue proceedings. So you've got to actually have a proceeding on foot.
Within the 2 years. The other interesting thing about the scheme is there's an upper limit on how much you can claim. If you're claiming under the Warsaw Convention, I think, again, putting on the French civil law hat, it's 250,000 francs.
I think it converts back to 500,000 Australian dollars today.
So that's the upper limit.
Yeah, because the Commonwealth Civil Aviation Act, which is the Carriers Liability Act here in Australia, they have a limit, and I think that is the 500,000.
500,000
yes.
Limit, so that's, again, another feature. You know, the wording of the Act, I think, tries to restrict claims.
Yes.
Yep.
So anyone who's injured on an aircraft can't claim. It's got to be an accident which causes injury, and an accident's got to be an unusual event.
Well, why don't we get onto a case where someone actually won some money, Harry?
That's a good point. It's a good point. Mr. Povey, unfortunately, lost. Yeah, but no, there's been a few interesting cases. Patterson's case, someone he was a mining consultant.
Is hopping off a aircraft where you have to walk down a series of steps. Those steps didn't quite meet the tarmac, so at the bottom of the steps they had an artificial step that they put there. Let's call it a box. They put that there. This man was approximately 6 foot tall. He was 125 kilos. He's got his laptop like all the people carry these days. He's stepping down off the aircraft. He goes to take that final last step. Lo and behold, the step moves. He ends up on his knees going forward and ends up getting injured.
It was very, very lucky, I think, because the evidence wasn't that strong on the issue of how he got injured.
Well,
no, they step and it's actually moved. So the inference was it moved because of the step being defective, I'd imagine, but...
it wasn't placed properly or it was slippery. I mean, it was an unusual event. I think I thought the defendants had a weak case on liability.
Well, Harry, one of the things they threw at the poor plaintiff was the fact that he was overweight. I mean, I don't think it went to
125 kilos, 182 centimetres.
Well
he's a big judge. No, he's a big lad.
Yeah. So they say that's why the step moved. It wouldn't have moved otherwise, but that didn't go down well.
But no, I thought it was a weak argument.
Okay, the argument they put was, do you expect him to have jumped? Or do they, he didn't do anything. It was external. It was the step moved, therefore it becomes an accident. Once you've overcome that issue, then the case went on to assess damages. I've got a chance just to mention damages, because, Tony, you said earlier on that girl got $290,000. Believe it or not, Mr. Povey got $439,000.
Mr. Patterson. Patterson, yeah.
$439,000. Now, he got $50,000 for his pain and suffering. That's reasonable.
But, it was a knee injury. It was that's light.
Well, in this jurisdiction in New South Wales, that's what they paid. Yeah. In relation to because it took so long to get to court, they gave him interest of $20,000. They gave him an economic loss because he couldn't work of $250,000. Topped that up with another $115,000 for interest because he hadn't received that money, and some out-of-pocket expenses.
How much was the interest component?
$115, because the accident occurred in 1998 and this decision was handed down in 2009. So for 10 years, he was without his money.
Yeah, that's the issue we were talking about last week.
Correct.
Delays
by defendant lawyers. Well, the insurance ultimately paid, Tony. So
I don't think in every case you can get interest like that. It must be
in New South Wales.
So that's just of interest. Why was the case worth $439,000? Delay played a factor.
Yep. So a big chunk of it was interest.
Yep. The next case is a Malaysian businessman sitting in first class.
Yes.
And the seats were defective, and he injured his back. He had a prior back injury, but it was aggravated by the flight.
Yes.
So he succeeded.
Yeah, it
He
was
had a disc
outrageous,
prolapse.
really. No,
Yeah.
it was,
He ended up with a disc prolapse. It's not. It's
No, he had degenerative back. He had problems in 1989, up to 89, and for 10 years prior to this flight, his back had been pretty much symptom-free.
Yes.
But the funny thing about this case is that he was in business class, and you've got a situation where
It was defective seats.
the seat's no good. I mean, you're paying extra money for a seat, and you can't even get a proper seat.
Yeah,
And he asked to be moved.
You'd be guessing at the airline moving or something like that, causing some damage. But you don't have to prove negligence.
No, but you still have to prove.
You prove it's an accident, and the argument was the defective seat an external event which caused this damage.
It was not only just the defective seat, it wouldn't go back, so he couldn't get back to the sleep position. They brought it down manually, but then in the seat itself, there was another factor. The lumbar support couldn't be used electronically. So here's a fellow laying down on a defective seat with a bulge in the middle of it called the lumbar support. So that was and he asked to be moved. They didn't move it. It was external to the event was then classified as an accident. And as soon as it was classified as an accident, he then gets the no-fault provisions.
Yeah. So, I mean, Tony, there's a case where, say, someone's sitting in a flight with a tray, someone comes and pours some coffee in. If the flight suddenly moves, the coffee spills and causes injuries, then that's covered. But if you spill the coffee...
It's actually arguable because you've got to be able to prove that it wasn't you that caused this coffee to spill. If you can't prove that it was external to yourself, you've got issues.
Yep, it's got to be unusual and unexpected.
Unexpected event on a flight. So, look, it's complicated law. I think you raised the issue before about extra insurance.
Yes, there's clearly the people should get travel insurance, and make sure when you do take your travel insurance you read the policy, because this law is very restricted, as we've seen in these cases. It takes an unusual or unexpected event. The situation is get travel insurance, and if you need to seek advice from a lawyer.
Martin, this is one area where you probably would want to get advice because it's very, very tricky.
There's also, you get covered with your credit cards. Some credit cards you also can be covered by other policies.
Superannuation might be a 24-hour cover as well.
So, these are aspects that need to be examined.
Yeah, but injuries on an airline and getting on and off an airline are prima facie covered, but there's a lot of restrictions and a lot of issues to consider when giving advice, Tony.
Go to a lawyer. Ring him.
We're about to take a short break. Thanks, Martin, for joining us for the last 2 weeks running, and it's been a very interesting discussion.
Thanks, Martin.
Thank you.
When we return, there'll be airmails, emails, and we'll be answering your questions with Viv's mailbag. Thanks.
Thank you.